So from yesterday, we've been tracking and following for you the stories coming out of the Supreme Court. It was something that a lot of us woke up to. The CJN resigned. Very unusual. Now, the number two person, the man who is next to him as far as the hierarchy and the ranking of the Supreme Court justices in the nation is concerned, Justice Ariwoola, was sworn in by President Buhari. Well, today, the Senate has resolved to continue with its investigation into the crisis in the Supreme Court despite the resignation of Justice Tanko Muhammad as the Chief Justice of Nigeria. Lawmakers in the upper chamber of the National Assembly made a resolution during plenary today following a motion moved by the chairman of the Senate Committee on Judiciary, Human Rights and Legal Matters, Senator Opeyemi Bamidele. Justices of the Supreme Court had in a petition addressed to the immediate past CJN was concerned over the deplorable welfare conditions and difficult working environment in the Apex Court. Days after the development, Justice Muhammad resigned as the CJN on the grounds of ill health, cutting short his tenure in office, which was expected to last until 2023. Cleaning the judiciary organs tables. That is what it looks like to all of us right now. When these allegations are flying left, right, and center, and these issues are coming to an institution that is supposed to correct the ills of the society and serve as an arbiter in any of the conflict that we say. Now we're seeing conflict emanating from that institution. It gets us talking. And we're getting one of the senior lawyers in Nigeria today. I'm being joined by Mr. Justice Maikyau, who is a senior advocate of Nigeria. Thank you so much for joining us tonight.
Thank you so much for having me.
As a very senior lawyer in the land, the development in the judiciary, especially in the highest ranking court of Nigeria, the Supreme Court, how did this come to you?
Well, the situation in the Supreme Court is most unusual and gives very serious cause for concern. And so we've seen some unusual developments that started with the leak of that letter written by 14 justices of the Supreme Court to the outgone Chief Justice of Nigeria. It's unusual to have justices or even judges of a court make such a complaint. The experience of the judiciary is not unknown to all of us. It's most unfortunate that the judiciary has been neglected over the years, and that neglect is actually what culminated to what we saw in the letter that was written by the justices of the Supreme Court to the then Chief Justice of Nigeria. And it had to do with the refusal by the institution that has the responsibility to look into the salaries, allowances, and emoluments of judicial officers in this country to perform its own statutory function, constitutional function in making sure that it reviews the allowances of the judges and justices of the Supreme Court, or all the courts in the land, superior courts of the land, to make sure that they reflect the reality of our situation. That hasn't been done. The last time in this country that the law which prescribes or made the determination for their salaries and allowances actually made such a determination was in 2008.
So the judges are poorly paid?
They are terribly and poorly paid.
We understand that they're being paid as much as professors in the university. Less than ₦1 million, about 800, 900,000. Is that the true position of things?
That is the true position of things. Aside from the poor salaries that they get, I give you an example of judges of the Federal High Court, for instance, who haven't had their salaries reviewed since 2008. Now they are posted from one judicial division in the country to another judicial division across the country. So there are vehicles which they use to move around when they are posted, or even when they have to move from one point to the other because they have to leave their families in one position and at a particular station to be able to move around. They cannot be moving with their families each time they are posted from one judicial division to the other. So they need to have functional vehicles that would convey them to perform their judicial duties. Those vehicles have not been changed for years. The same thing with the justices of the Court of Appeal. I mean, we have several divisions of the Court of Appeal have to move from one division of the Court of Appeal to another division of the Court of Appeal.
So there's a huge disparity between the arms of government. I mean,
absolutely.
Is the judiciary, in quote, intentionally badly or poorly funded to harm it?
Well, I think there is deliberateness in it.
To make it subservient?
I believe so.
I mean, who are those responsible in the funding or the apportioning of funding for the judiciary? I mean, all of us have been talking about the independence of the judiciary. A lot of people will say, there's nothing like that. It doesn't exist. So where do we start from?
Well, we should start by guaranteeing the financial independence of the judiciary. A situation where the judiciary goes cap in hand, looking for what to sustain itself. It's really terrible for the nation. You've just made the comment that that is the arm of government that sustains the nation, because whenever there is dispute either between individuals or any government agency or even the federal government and the state, it is that arm of government that is given the constitutional responsibility of settling that dispute. So could it be that the judiciary is being pauperized so that they will pander a certain way to those who have the responsibility of funding it? Maybe so. And I say that there is deliberateness in this because we haven't seen any attempt by the government of this country since 2008 to make an attempt to improve on the welfare of the judiciary, of members of the judiciary. The judges are poorly paid. The justices of the Court of Appeal are poorly paid. The justices of the Supreme Court, you could see in that letter they wrote, talking about the fact that they couldn't even make internet available. That is ridiculous and totally unacceptable.
We understand that even some of my lordship in the Supreme Court now, longhand, writing their own judgments before they even give it to their assistant to type.
Of course, they do not have the tools to work with. Very few of the courts have been digitized.
Maybe for the sake of our viewers who may not understand how these courts operate and the judgment, sometimes judgments could be read for 2-3 hours in the Supreme Court.
Yes.
So I'm talking about the volume. Can you describe sometimes the volume of Supreme Court judgments?
Okay, so
average.
So
people can understand when they say that judges take their time to write the judgment. What is the volume averagely? What does it look like?
Okay, so I give you an example of a matter that comes from the High Court, which goes through the process of appeal to the Court of Appeal and eventually to the Supreme Court. You could have bundles of documents that were submitted first and foremost to the High Court, maybe running into thousands of pages, and then another set of documents that went to the Court of Appeal, another maybe 1,000-page document, before it now gets to the Supreme Court. So you can see in just one matter, in one appeal pending before the Supreme Court, a volume of about 3,000-page documents, which the Supreme Court, the justices of the Supreme Court would have to sit down and go through in order to understand what happened,
page
by page, to understand what transpired at the trial court, coming to the Court of Appeal and the Supreme Court. It is only when they are able to do that would they be able to hand down a dispassionate decision. Now, they have to do this without any aid of technology because these documents are hard copies of documents that have been filed. Electronic filing of documents have not really gained traction in our judicial system. So most of the courts now still file hard copies of documents. Of course, there are certain courts in this country that have been digitized and electronic filing of documents are already being done, but not without their challenges. I know that I was privileged to be at a function in Lagos, and the practitioners in Lagos are complaining seriously about the challenges of the online filing of court processes in the court and how that has actually caused a clog in the administration of justice, because cases that are filed online take as as long as maybe a month or two.
So there's a need for urgent reforms.
Absolutely.
Now, Justice Ariwola, I mean, whether or not that's going to be the decision of the process leading to how a CGN is being appointed, whether or not within the next 3 months or so, it will be appointed as a substantive CGN or not, has a lot of work, is work cut out for him, isn't it?
It definitely has a lot of work cut out for him.
Where should this begin from? Because first and foremost, are these shadow cast on the judiciary based on the allegations that are flying around about the underhand dealings, the allegations of money lining pockets and all of that? How can the judiciary take itself out of this?
Well, it's important for us to actually regain the confidence of the public. If we must play our primary role as the agents to drive the sort of reformation, the sort of repositioning, and the recovery that we need in this nation. And earning the confidence of the public means that we have to be transparent, we have to demonstrate sincerity and integrity in the discharge of this function. Now, the Nigerian Bar Association in January of this year convened a justice sector summit. And I think the leadership of the Nigerian Bar Association probably saw this day in convening that justice sector summit. Because what were principally talked about in that summit, number one had to do with the administration of courts. Is it time for us to bring professionals to run our courts so that we don't leave those who are supposed to perform judicial functions with the responsibility of administering the court? That would help the accountability that we are looking for in the judiciary. In that same summit, it was Honorable Justice Amina Ogi that came to deliver the keynote address. It was such a frank and sincere discussion that we had. And that saw also very senior lawyers commit to the implementation of the committee.
And it looks so much that we know what the problems are.
Oh, we absolutely know what the problems
solutions. I mean, is it the job of the Attorney General of the Federation to take on these reforms?
Well, he has a role to play.
Because we saw that happen in Lagos years ago.
Exactly. He has a prominent role to play. Every lawyer in this country also has a prominent role to play. And we have to understand first and foremost that we are called to serve the person of justice, Sheun. And the service to justice should be the primary consideration for all we do. And I say this for all legal practitioners, whether serving on the bench or serving as members of the bar. That is what we are called to do.
Now,
by the time we allow other motivations other than the need to serve justice to determine what we do, either on the bench or as members of the bar, then we begin to have this sort of issues that we have to deal with.
Quickly, Ms. Maikyau, the Senate has promised to intervene. Now, the concept and the principles of separation of powers now comes to play now.
Yeah.
How does a bar or the bench or the judiciary generally welcome this kind of intervention? Is it necessary?
Well, I think it's necessary to the extent that we need to know exactly what transpired. And that's the way to be transparent. Actually,
so the judiciary cannot clean its own mess.
No,
would there be a need for an outsider, another arm of government to do that for them?
Well, so the National Assembly plays a supervisory function over the judiciary.
An oversight.
An oversight function. So, and then it appropriates what goes to the judiciary. So it has that oversight function to determine whether the things or whether the monies budgeted for the judiciary were actually applied for the purpose for which they were budgeted. So to that extent, yes, they could perform that oversight function in determining the budgetary provisions that have been made and to find out whether or not those budgetary provisions were properly appropriated.
All right, quickly, because we have a little more time to spend. Now, the NJC will have a lot of work to do, and the necessary disciplinary body in the bar and the bench have a lot of work to do, isn't it? Exactly. To clean off this mess.
It's absolutely.
The ones that are relating to financial impropriety and the ones that are relating to administrative impropriety, isn't it?
Absolutely.
Now, if you look at it, would you say the outpost of the justices were necessary?
Well, I think given the situation, they probably didn't have any other option.
They were moved to the wall.
They probably never had any option other than to do what they did. And I think the justices themselves must have considered the repercussions, and they must have come to the conclusion that this is the only thing that they could do in order to bear out.
Save a sinking ship.
Exactly.
Because it looks like all of us are going to sink.
Are going to sink, so let us do this to salvage the situation.
Now, the outgone CGN was honored with the CGON, a national honor by the president. Would you say that was necessary, considering the kind of atmosphere that led to his exit or the resignation?
Well, so that is the prerogative of the president, first and foremost.
Do you think morally
now morally, and I must commend the outgone Chief Justice of Nigeria for the decision to quit the office on the ground that he did. Once you find yourself having health challenge, which makes you unable to perform the function of your office, then the honorable thing to do is to take a decision to quit that office. That is an unusual thing to find in our own client. And to that extent, I must commend the Chief Justice, the outgone Chief Justice of Nigeria, Dr. I.T. Muhammad, for taking that decision to quit on health grounds. That has nothing to do with the allegations that have been made in the letter written by the Justices of the Court of Appeal. And you must understand that in our system, the fact that allegations were made aren't conclusive of the guilt of the person. So this has to be looked into, and if any blame is found, it will be apportioned accordingly, and that would be dealt with.
That honor, was it natural? Was it traditional? Was it for the position of the CGN?
Well, I know.
Was it statutory?
Past CGNs have always carried that title, that honors of GCON.
But because the criticism comes the fact that, look, when all of this cloud is over this person, and what you did was to honor him as an exit badge. I mean, a lot of people who have queried that decision say, look, you should have allowed a bit more time to look into what really happened.
Yeah, so it would be a bit presumptive to simply conclude that, oh, all the things that were said in that letter, worrisome as they are, were actually he's found wanting in those respects. One thing that we are sure of today is the fact that he resigned on health ground. All the other things, and you know, I don't make light of what the justices of the Supreme Court have said. For all the justices of the Supreme Court to come and say that these are our experiences, no doubt they are true, and they are things that they can substantiate, but whether or not the outgone CJN is complicit in getting those situations to be the way they are, it's another thing altogether. Right. That is what we determine his culpability. Mm-hmm. So he's presumed innocent with respect to those issues. What he did or didn't do, you know, in becoming complicit in the situation, the alleged mismanagement and all. So he is presumed innocent in that respect. So the only thing that we know about today is the fact that he's suffering from health challenges, and on that ground, he has decided to leave the office.
There's a lot of introspection that will be done in the coming days, and Justice Ariwola sure has his hands on the work and has his work cut out for him.
Justice Ariwola, I should also congratulate. A wonderful jurist, someone who is highly cerebral, someone who is temperate, a man of honor and integrity. I can attest to that. And I mean, you saw his colleagues when they went to the Supreme Court, how they rallied around him. And they had smiles all over their faces.
All right.
I would commend to my Lord Honorable Justice Ariwala to look at the communique that was issued by the Justice Sector Summit that was convened by the Nigerian Bar Association.
We must leave it at that. Senior Advocate of Nigeria, Justice Maikyau. Thank you so much for your intervention.
Thank you
tonight.
so much. For
appreciate it.
I appreciate it.
But that's how we draw the curtain tonight on the program. Many thanks, everyone, for watching. Sean Kimberley. Bye-bye.